let's get more insights on this matter. And joining us on the line is the Director of Legal Affairs at the Ethics and Anti-Corruption Commission, David Todd. David, good morning.
Good morning to you.
Thank you very much for speaking to us. Welcome to the Situation Room.
Thank you.
Now, David, I've just read part of the statement by the EACC boss yesterday, but also you can just give us, some meat on this Kidero win, if we may call it that.
Okay, thank you for giving me this opportunity, and by extension, the Ethics and Anti-Corruption Commission to attend to this interview. What I would say is that much of what you have said in relation to the case starting in Kidero and this associate is the factual position.
Mm-hmm.
What happened is that EACC received information that Kidero and his associates had amassed wealth which was disproportionate to his non-legitimate source of income. Mm-hmm. And first and foremost, maybe for Kenyans to know, what is this that we talk of unexplained wealth?
Mm.
Unexplained wealth is derives its relevance from the offense of illicit enrichment,
mm-hmm.
as captured in the African Union Convention on Prevention and Combating Corruption, and also under the United Nations Convention Against Corruption.
Mm.
And Section 2 of our Anti-Corruption and Economic Grants Act states that such property or pecuniary possessions that are disproportionate in value to a person's non-source of income and for which there is no satisfactory explanation. That is the catchword. There is no
satisfactory explanation.
Yes. Somebody has amassed a lot of wealth. It is known to be disproportionate to his non-legitimate source of income.
Mm.
Non-legitimate source of income, not the illegitimate source. And the person has no satisfactory explanation.
Mm.
So for the case of Kidero, that was the allegation we received.
Okay.
And in order to establish or to verify, the commission obtained warrants to search his premises and also to search his accounts. And in the first instance, Dr. Kidero and his spouse, Dr. Susan Kidero, they filed petitions in the High Court. That was in 2016.
Yeah.
Challenging the warrants which had been given by court to investigate their bank accounts.
Mm.
At around the same time, Okia Omutata had also filed a case to say that EACC has no powers to investigate criminal matters.
Mm-hmm.
So the case of Okia Omutata and the one for Dr. Kidero were consolidated.
Yeah.
And a 3-judge bench dismissed that petition.
Mm-hmm.
So when the petition was dismissed, it now gave way for EACC to apply for the second warrants, which are now subject to the judgment which was delivered recently, and which you have talked about. So you can see that there was an initial attempt to block EACC in 2016.
From accessing the bank accounts, basically saying...
From accessing the bank account.
Mm.
And the EACC was stopped pending the hearing of that petition.
Yeah.
And after the matter was consolidated with the case by Omutata and it was dismissed by a 3-judge bench, it now gives EACC the green light to go for the second attempt for such warrants.
Mm.
And it actually went to court, obtained warrants, and cited premises. Kidero again came with his associates. They filed another petition similar to the petition that was filed in 2016. And the EACC was stopped again. Mm. So it's until recently that we obtained the judgment that the EACC can now proceed with further investigation. And perhaps you have captured rightly what they were complaining about in the recent petition.
Explain that bit of saying that you need to be notified if a warrant is issued against you. What was that argument?
Well, this issue of notification arose from a case filed by Professor Tom Agenda, which was also seeking to stop EACC from undertaking investigation, and he argued that EACC ought to give notice to a party against whom it intends to undertake a search, and that obtaining a search warrant without giving notice to the party infringes Article 47 of the Constitution of Kenya. And the High Court, Naona, then agreed with him, and EACC was stopped, and the High Court held that a notice ought to be issued.
Now,
it was upheld by the Court of Appeal. I hope I'm not mixing up things. These are two different cases.
No, it's all right. I think you're
still
still
on the same
explaining
idea.
on the same matter, because the matter is on whether you need to notify me before you even obtain orders against me.
According to the judgment, you need not notify.
All right.
Okay.
All right.
What is this new?
If you are to notify the person, you would be alerting the person.
It's negating the whole process.
To tamper the evidence. It is self-defeating.
Yeah.
All right.
You can not forewarn somebody that you are coming to such his house, and maybe there are things which are incriminating.
Now,
That person is likely to hide those things.
David, in terms of this ruling now, what does this now mean for the numerous cases that are waiting, and also for this particular case? What does this then open doors for?
Well, the impact of this ruling, or the judgment, is that EACC can now proceed to undertake investigations in the usual manner that it has been undertaking, applying to court for search warrants if they deem it is necessary, or for warrants to investigate bank accounts.
So, given the position that the EAC now finds itself in, does this probably mean, therefore, that some of the cases they've had, say, for instance, with respect to governors and other individuals in the country, that this now might actually speed up some of the processes regarding these cases?
Yeah, the judgment, in essence, gives the leeway for EACC now to proceed, as I said, if they intend to apply for any such warrant or warrants to investigate accounts. Because the court has come out clearly to say that no party being investigated needs to be notified before a such warrant is applied.
It seems to me that this is vital in being able to get any kind of evidence or information that you'd be looking for then to go forward with a case. Now, if you want to look historically at some of the cases that were done before, are we essentially saying that because of the whole constitutional rights issue, the obtaining of these warrants then to be able to look into property and accounts never happened on the basis of constitutional rights?
Well, it has been happening before, but what happened is that in 2008, when we attempted to follow unexplained assets touching on one Stanley Bombo Amuti, which you may be aware of, that's been in the press in the past.
Yeah.
The judge of the High Court, at that time, Justice Rawal, declared Section 55 of Anti-Corruption and Economic Crimes Act unconstitutional, which is actually the section EACC has been using to go for unexplained big assets.
Yep.
So when the judge declared that section unconstitutional, it held back EACC from filing other cases for unexplained assets. It's only until around 2014 or 2015 thereabout when the Court of Appeal overturned the judgment of the High Court, which ruled that Section 55 was unconstitutional. It's only around that time when we now started again to follow up other allegations of unexplained assets. And we commenced the filing with other things. But as for the warrants, the EACC has been applying for warrants up to 2018 when this issue of notice came up.
And how has it helped? And how has it helped with this application of warrants and then that being used as direct evidence in cases? How has that helped to either close cases or at least move along the progression of cases previously?
You see, the issue of warrants is very crucial when you are undertaking an investigation, because you are able to obtain information which you may not have obtained in any other way, especially for financial investigation. If it is alleged that somebody has amassed a lot of wealth, one thing that goes to mind is that there might have been money which have been going through the bank account.
Yeah.
And the only way to obtain information from the bank is obtaining warrants to investigate the account. And it is after getting that information that you can now analyze and be able to ask the person where that money came from. And this is what EACC was basically doing. It had not. I think the information going out there is that EACC had seized the property of Dr. Kidero.
So
we had not seized any property. We were in the process of investigation.
So you were still allowed to continue transacting on the accounts?
In other situations where there is evidence, we have preliminary established that these monies are illegally obtained, we apply for order to freeze the account.
But I see that this is also a likelihood that the EACC could use that stick a lot often than not, where you come in and you say we preliminarily believe that what's on this account was irregularly acquired and therefore freeze. And thereby, as you're continuing your investigations, which have no timeline, you're basically affecting somebody's livelihood. So this person is not able to access their money in their account. They is not able to transact with this money. And EACC can take 10 years investigating this particular matter. What's the recourse for that?
Well, as I said, EACC only files for freezing of the order when at preliminary stage it is satisfied that this money has been illegally obtained. It is not a situation whereby EACC just goes to court and applies just because it is undertaking investigation and applies to these accounts. It rarely do that. There are so many applications we have done, and persons have been operating their bank account. And in fact, for many instances, it is only in those situations whereby EACC has, on a preliminary basis, considering information that it has received and other evidence that is in its possession, that it is able to say these monies should be processed.
I hear that. What I'm just wondering is that this is EACC considering and believing, but I don't have to agree, and maybe I don't agree, and maybe even if we go to court, you will not be able to prove or may be able to actually show that what you thought you were right on, what you were actually wrong. In the meantime, my life is impacted.
Maybe I could give some light there.
Yes.
Under Section 56 of ASECA and the Corruption and Economic Crime Act,
Yep.
EACC is allowed under the law to file for a preservation order.
Okay.
And that preservation order is supposed to last for 6 months. And this is obtained through the High Court.
Okay.
If any party is dissatisfied with the High Court order, the party can go to court upon being served with the order to set aside the preservation order.
Okay.
And so you can see there is unfairness. The party has the opportunity to argue in court, and the EACC also has the opportunity to demonstrate why those funds should be held. And this has been happening more often, where we feel that funds or property should be preserved. So the party is not denied. It is not the EACC. It is the EACC moving the court and satisfying the court that there are good grounds or reasonable grounds for preservation of these assets. So you can see there is fairness. It is not about EACC going to court and filing an application and undertaking investigation for as long as it wants. I hope I'm clear on that.
Yes, now that's very clear. Now with this new kind of jurisprudence that the EACC is seeing, things are going your way in court. Are things also going the same way in terms of speeding up your investigations and taking the files to the DPP, also taking the cases to court?
Oh yes. Therefore, now that the issue of COVID has come in, and things are a bit slow, but the investigations are still ongoing, and there are matters which are being sent to the office of the DPP. So it's a process, because the DPP has to be satisfied that we have obtained sufficient evidence to charge something.
All right, with all of these things taken into consideration and how the fight against graft has been, I mean, this one case being as one that could, shine the light on this, do you think that you could then have a trail of successes in terms of how the EACC has been able to fight graft?
Well, in terms of asset recovery, I would say that the EACC has done a lot. And I would say that since 2014, EACC has recovered assets over 13.2 billion. And some of the assets include 1,800 acres of land land at Naivasha. We have the University of Nairobi property, which was recovered recently, which has been in court for a very long time. And we also have railway land in Kisumu, which have always been highlighted in the first case. A chunk of land which has been grabbed by persons. And the courts in Kisumu have ruled that land be returned to Kenya Railways. And even the High Court in Kisumu, by the way, the High Court in Kisumu had been grabbed. And
Interesting.
it had been grabbed. And the EACC went to court and it won.
And so
and
just looking at how this continues, then you have goodwill to be able to fight corruption. Do you think, looking at coming from as high as the president, to be able to say, all right, this is something that we are going to fight and keep fighting until, we get to a wonderful place of, saying that we've been able to keep corruption at bay. Do you have goodwill as the EACC from the president, as far up as that, to keep fighting corruption?
I think it is in the public domain that the president has come out strongly in talking about fighting corruption. And he has also pledged support not only to the anti-corruption body, but all the bodies that are fighting corruption.
Right.
In terms of budgetary support.
Okay.
And the president has come out strongly in that. It is not that what EACC needs is the resources.
And resources here is money.
And the resources here is money.
Hakuna pesa bwana to. David Cho, Director of Legal Affairs at the Ethics and Anti-Corruption Commission, thank you very much for speaking to us, and congratulations on all the gains that you're making in the wheels of justice in terms of fighting corruption in the country. We wish you all the best.
Thank you very much.
And as we
Thank you.
keep saying, we just want blood on the streets. All the best, sir.
It is you saying.
Asante.